Hello everyone, this is Urvashi Chauhan and I welcome you to another episode of Courts Today by Livelaw, where we bring you the latest developments from all courts across India. Let us start. Let me start by briefing you about Day 4 of the Supreme Court hearing on the batch of petitions challenging the dilution of Article 370 of the Constitution. The Constitution Bench, comprising Chief Justice of India D.Y. Chandrachud, Justices Sanjay Kishan Kaul, Sanjeev Khanna, B.R. Gawai and Surya Kant, is hearing the matter. Today, Senior Advocate Gopal Subramaniam, appearing for a resident of Jammu and Kashmir, argued. He appraised the bench that Jammu and Kashmir Constituent Assembly did not intend for Article 370 to be abrogated and that it had envisioned for the Constitution of India to apply to Jammu and Kashmir with modifications and exceptions and not as it is. Reference was made to Section 147 of J&K Constitution, which bars any amendment that seeks to make changes in the provisions of the Constitution of India as applicable to Jammu and Kashmir. He further said that the Constitution of J&K is intended to be applicable to J&K. It is a constitution because it was framed by a constituent assembly, and that the exercise of power under Article 370 must not offend the basic principles of Constitution, that is federalism and supremacy of the Constitution. He also said that the purpose of Article 356, that is the power to amend the Constitution, and Article 370 were not coincidental. Further, Senior Advocate Zafar Shah, appearing on behalf of the Bar Association of Jammu and Kashmir, referring to the instrument of accession, submitted that when the Maharaja of Kashmir had entered into the instrument of accession, he did not enter into a merger agreement. Union of India was by itself one authority and Maharaja was another authority. Sovereignty was transferred, but not the power of legislation. His arguments ended for the day on the question that how does the Constitution of India treat a state that has not merged but ceded. He will continue with his arguments tomorrow. Stay tuned with us. You can also watch live proceedings from the Supreme Court on our YouTube channel. In an important update from the Supreme Court, it has observed that the protection of Section 197 of CRPC is not applicable to a person working in a nationalized bank. For your knowledge, Section 197 of CRPC prescribes that any judge or public servant who cannot be removed from his office without the sanction of the government in order to prosecute him for any offence committed in the discharge of his official duty, previous sanction or permission from state or central government, as the case may be, is required. Also, in the prosecution for the offences exclusively under Prevention of Corruption Act of 1988, sanction is mandatory for the public servant. In this particular case, the accused was serving as an Assistant General Manager, State Bank of India, Overseas Bank, Hyderabad. He is alleged to have conspired with the other co-accused to cheat the bank by sanctioning a corporate loan of 22.5 crores in favor of Swen Gentech Limited, Secunderabad. So an FIR was lodged against him for cheating and forgery. His petition seeking quashing of FIR was dismissed by the Telangana High Court. So he approached the Apex Court and the issue arose whether the appellant is removable from his office except by permission of the government. That is basically whether Section 197 of CRPC will apply or not. The court has significantly held that although a person working in a nationalized bank is a public servant, the provisions of Section 197 are not attracted at all because Section 197 is for cases where the public servant is such who can be removed only with the previous permission of the government. The appellant post is such that he can be removed from the office without the required sanction. Therefore, Section 197 of CRPC does not apply. You can read more about this important case on our website at livelaw.in. And now an update on the deaths of Kuno Cheetahs with respect to India's Cheetah reintroduction program. The Supreme Court bench of Justice B.R. Gawai, Justice P.S. Narasimha and Justice Prashant Kumar Mishra was hearing an application by an expert committee which was constituted by the court in 2020 to guide and direct the National Tiger Conservation Authority, that is NTCA, with respect to India's cheetah reintroduction program. 20 cheetah were translocated to Madhya Pradesh's Kuno National Park from the African continent and 4 were born in India. A total of 8 out of them have now died. The expert committee urged the top court to direct the NTCA to keep it appraised of latest developments and accept their advice and submissions. The Apex Court has closed the plea, taking on record submission of the centre that all the members of the consulting panel of Cheetah Project Steering Committee were being consulted to carry on the project in a proper manner and to ensure further deaths were prevented. The court orally stated that the number of deaths recorded so far was not low. In another update, the Kerala High Court has embarked upon an elaborate medico-legal discussion on the 2 concepts of gender and sex. This was in an interesting decision where the court was considering a plea by the parents of a child born with ambiguous genitalia, seeking the court's permission to conduct a genital reconstructive surgery for raising the child as a female. The question was whether the parents had the right to do so without the child's consent and ignorant of the child's orientation. The court said that granting such permission could result in severe emotional and psychological issues if, on attaining adolescence, the child develops orientation towards the gender other than the one to which the child was converted through surgical intervention. However, the court declared that such intervention could be permitted if recommended by a duly constituted medical board, and further, the court proceeded to issue a slew of directions for constituting a state-level multidisciplinary committee comprising of experts which shall examine requests for performing sex-selective surgeries. Significantly, Justice V.G. Arun observed that while the terms gender and sex were often used interchangeably in casual conversation, they were in actuality 2 distinct concepts. He further explained, sex refers to the biological characteristics of a person, particularly in relation to their reproductive anatomy, but gender is a social and cultural construct that encompasses the roles, behaviors, expectations and identities associated with being male, female or non-binary. This observation in the middle of a global movement towards making the society more inclusive towards LGBTQIA+ community is indeed a step forward in explaining the basic concept which is regarded to be alien by a large section of our society. The Supreme Court today adjourned the hearing of bail application of former JNU scholar and activist Umar Khalid in Delhi riots larger conspiracy case after Justice Prashant Kumar Mishra recused from the hearing. The matter was listed before a bench comprising Justices A.S. Bopanna and Prashant Kumar Mishra, considering Khalid's special leave petition challenging the decision of the Delhi High Court to deny him bail last year. The bench directed that the matter be placed before another composition on 17th August. You already know that Khalid has been behind bars since September 2020, awaiting his trial in the case under the UAPA for his alleged involvement in the larger conspiracy surrounding the Delhi communal violence of 2020. In an important update, the Supreme Court is set to hear curative petition against its 2020 judgment, which held that arbitration clause in an insufficiently stamped agreement cannot be acted upon. The question arose in a case where the Karnataka High Court appointed an arbitrator to decide the dispute between the parties, but the lease deed in the case was insufficiently stamped. The question was whether arbitration clause in such an insufficiently stamped agreement could be enforceable or not. In April this year, a constitution bench of the Supreme Court, by a ratio of 3:2 majority, had held that arbitration agreement in an unstamped contract is unenforceable. Now, a bench comprising of Chief Justice D.Y. Chandrachud, Justice Sanjay Kishan Kaul, Justice Sanjeev Khanna, Justice B.R. Gawai and Justice Suryakant has listed a curative petition against the 2020 ruling and has issued notice in the matter and has listed it for hearing on 24th August. For those of you who may not know, let me tell you, a curative petition is a legal remedy as a last resort to rectify or cure gross miscarriage of justice that may have occurred after a final judgment has been delivered. It is a form of review petition that aims to address error in any judgment that has become final. And now let me tell you that the recent Parliamentary Standing Committee on Personnel, Public Grievances, Law and Justice, in its 133rd report on judicial process and reforms, has recommended that the age of retirement of Supreme Court and High Court judges needs to be increased. While observing that increasing the age of retirement of judges would not only help the judicial system but also the public at large, specifically the litigants before the court, it said that the judicial system would be greatly benefited because a person with a wealth of experience by virtue of a long tenure in the High Court would continue to serve the High Court for a further period. Also, the MP, Mr. P. Wilson, while stressing the need for increasing the retirement age, has pointed out in the report that when Supreme Court judges upon retirement are functioning effectively as chairmen and members of various important tribunals, where the workload is sometimes heavier, why is it assumed that they cannot continue functioning as judges of Supreme Court till 70 years of age? However, as of now, the government has informed that there is no proposal to increase the age of judges, additional and acting judges of the high courts. And lastly, an application has been filed by the Anjuman Intizamiya Masjid Committee, which manages the Gyanvapi Mosque in Varanasi, in the district court to restrain the electronic and print media from publishing false news about the ongoing ASI survey of the Gyanvapi premises. As you already know that the ASI is presently conducting a scientific survey of the Gyanvapi complex as per the order of Varanasi district judge to determine if the mosque was constructed over a pre-existing structure of a Hindu temple. Today is the 6th consecutive day of the survey. Earlier this month, the Supreme Court had refused to interfere with the survey, taking on record an undertaking made on behalf of the ASI that no excavation would be done at the site and no damage would be caused to the structure. The application filed states that the ASI or its officials have not made any statement pertaining to the ongoing survey. However, social media, print media and electronic media are arbitrarily spreading wrong and false news about it, which must be restrained. Thank you for joining us. If you wish to know more details about the cases I mentioned here, you can visit our website at www.livelaw.in. Stay ahead with quick legal updates only on Livelaw. Do not forget to like, share and subscribe and support us. You can also support us by donating through the Thanks app button at the bottom of our videos or consider becoming a member at just 89 rupees per month.